I'm Matt Gearheart. This is No Holds Barred. We're here once again with Justin Sonniksen on episode number 4, Workers' Compensation. Yeah, Justin, I've given some cases from my own experience and asked you some questions we've talked about. I want to get in a little bit into, you probably have a myriad of cases that you could tell us about. But an issue that comes up is once somebody is, as you say, permanent and stationary, whatever the term is, and receives their permanent disability benefits, can they go back to work? For example, they're working as a firefighter or something such as that, and then they go off and get a totally unrelated, but get another job.
Correct. So to get temporary disability, that's wage loss while you're recovering from your injury. So if you're collecting temporary disability benefits, that's 2/3 of your income up to a maximum. You can't be working somewhere else while collecting that. It's illegal. So because the theory is you're getting this money because you can't work. You just had surgery, you need to be at home, what have you. So you can't work while you're getting temporary disability benefits. You have to put the insurance company on notice, hey, I found a new job, stop paying me temporary disability. Now, if you get a new job that pays less, then you can get into getting 2/3 of the difference between what you made before and what you made now for temporary disability. Mm-hmm. But let's say you've reached that point where you've plateaued and now you're at permanent stationary. So you get the up to $290 per week for however many weeks assigned by that percentage. And permanent disability is not really premised on whether you're working or not. So you get a new job, they still have to pay you $290 a week. So a lot of times my clients will call and say, hey, I'm working, but I'm getting $290 a week. Is that okay? But the permanent disability benefits aren't wage loss. They're not based on you can't do your job anymore. Whether you're back at your old job or at a new job or you're at home, they have to pay you $290 a week. Now, technically, if you are working at your old job, you don't get paid the $290 a week until they settle the case. So when the parties lock in that percentage number, then they have to start paying you the $290 retroactive to when you were, permanent and stationary. So if you're actually working full time, you won't get permanent disability benefits until we reach a settlement, and then at that point they pay you retroactively. So it's a little quirk in the law they added about 10 years ago now. But the basic theory is that you can work and get permanent disability benefits because it's not wage replacement loss. Yeah.
Well, that's good because that answered the question that I was asked and I've been asked in the past. And when you said that your clients called you and said, hey, I'm getting permanent disability, but I've been offered a job. Can I do that? Or can I continue to get this benefit? And the answer is yes.
Yes. Yeah, you can work and collect permanent disability benefits. There's nothing illegal about that.
Yeah. So what I want to do now is just, I know in your experience, 19 years, that's a long time doing workers' comp, and I'm sure you have lots of interesting things, but some of the issues that have come up in some cases, because I've asked you some questions that perhaps you wanted to talk about. Can you tell us some of the cases that might make a point of some of these issues that you found particularly interesting in your career?
One thing that you'd asked me about was when do I need to hire a lawyer? And we had talked about the situation where the worker had gotten an old award of 10% and then a new one of 50% on the other knee. And I was explaining that the system is progressive, so a 50% award is worth a lot more than two 25% awards. And so you say, well, that's not fair to the worker. They get a lot less money if you're injured twice than if you're injured once. But there's a state fund that comes in called the subsequent injury fund that makes up that difference. If the worker suffers 2 injuries and then their overall disability is up here, but they only got paid as if they were down here. So the benefits are very hard to get. There's a lot of statutory requirements that have to be met. So that would be an example of when you need to get an attorney to file that kind of claim, because I've never seen an injured worker figure it out on their own. I can barely figure it out. But to take an extreme example to make my point, let's say you were born with one eye, and you go to work, and as a result of the work injury, you lose your vision in the other eye. So now you're 100% disabled. Well, the employer doesn't pay the 100% because they only caused you loss of one eye. But the worker can't work anymore. They're 100% disabled. So this state fund comes in and pays the difference between what the employer pays you for the loss of the one eye and the fact that you're 100% disabled. I mean, that's an extreme example, but that's somewhere where you would definitely need an attorney for, because it's a very convoluted system, and trying to figure out when you qualify can be challenging. But in terms of other instances that kind of illustrate what we're talking about, so the Workers' Comp Board strives to find industrial injury wherever possible. One of the categories to being excluded from insurance coverage is if you intentionally cause your injury. So if you intentionally mean to injure yourself, you can't get workers' comp benefits. But there was a case once where as a police officer, he just got off his shift, just immediately off his shift. He's angry, and he punches the locker out of anger just because he had a bad day at work. Just punched his locker. And so the city denied his claim, saying, well, you intentionally injured yourself. You intentionally hit the locker. You injured your hand. That's not workers' comp. And his claim actually prevailed because he testified, well, I intentionally hit the locker, but I didn't want to injure myself. I was just in a fit of rage and slammed my head against the locker, and they ended up finding injury, saying, well, he didn't intend to injure himself. The action was intentional, but the result wasn't. So it's just an example. Peace officers tend to do well at the Court of Appeal. That's what we always say at comp. There's a lot of presumptions for police officers, and so I'm not sure if everyone would have got that same kind of lenience, but it's kind of an example to underscore that they do strive to find injury whenever possible. And a lot of times that actually, a lot of those cases come out of a lawsuit where the worker is suing the employer, and the employer wants to go to workers' comp because they want it's called the exclusive remedy, because that you can't be sued for monetary damages. So they want it to be workers' comp because their payout is way less. So, for the employer side, they benefit from workers' comp too, because if you could be sued for some of these catastrophic injuries, a lot of these businesses would go out of business. But you have workers' comp insurance, very limited damages. So that was another theory behind it, is to keep the economy going so that you don't have this protracted litigation every time someone gets injured at work. In terms of other interesting cases, I had one where, the general rule is you can't sue your employer for an injury at work. There's a kind of an obscure exception to that, and I actually had one of these cases. It's if the employer fails to install a guard on a power press, and that is the proximate cause of the injury, you can sue the employer for damages in Superior Court. I actually had one. I couldn't believe when I had it. I was like, this is such an arcane exception, but it actually happened. He ended up losing an eye as a result. The dye shot back at him in the eye, and he was able to sue the employer in Superior Court on top of filing his workers' comp claim. So there are some instances where you can sue the employer for an injury that happened at work. All right, so going back to the third-party issue, I have a case where you get into concepts of employer fault. Now we can say the word fault, because now we're in the civil arena. So I have a client who worked for a traffic company, works as one of those guys flagging down people to slow down. They put the cones out, what have you. And he's struck by a car, moving, pretty serious injuries, struck by a moving vehicle. And so the workers' compensation insurance company is paying a lot of workers' comp benefits, and they want to get their money back from the driver that struck him. And so in this is where it gets really tricky, this area of law, because these kind of determinations are made at the Workers' Comp Board in terms of who is at fault, because the employer doesn't automatically get all their money back that the insurance company paid. So if the employer is found to have been at fault in part for the injury, you reduce their recovery rights by that percentage. So let's say let's say my client got a recovery in the civil arena in that case for $200,000. The workers' compensation insurance company says, all right, now we want a credit for that $200,000 against our future workers' comp benefits we have to pay to the worker. And if there's no employer fault, they'd be able to stop paying workers' comp benefits until the $200,000 had been expended. But if there was employer fault, then you have to look at, what's the total value of the case from a civil perspective. You figure out the percentage of the employer fault, and then you multiply that times that percentage, and that's called the threshold number. So that's the number of workers' comp benefits the insurance company has to pay before they can assert that credit. So, those determinations are made at the workers' comp board. So it's interesting, you'll have judges making these determinations on fault when we're not used to that because it's a no-fault system. So, that's a case where we were able to chop down their lien quite a bit. You have the lien and you have the credit rights. Those are two different things. So the lien is they want their money back for what they paid versus the credit for future benefits that they don't want to pay because they try to prevent what's called a double recovery.
Yeah.
So, in that instance, we were able to get a good deal on the lien and get them to drop any credit rights in exchange for giving them, the insurance company, some of the money back because of this employer fault issue. Because, we were going to say if this goes to trial, you may have to pay $300,000 in comp benefits before you can assert that credit. So,
well, it's interesting because I've had that exact experience, and I want to talk a little bit about what the audience may not understand, the idea of estoppel. Somebody is stopped from proceeding, going to trial on a case. Indemnity, there was an indemnity claim by a subcontractor against the general contractor. A worker was injured on a ladder. It was an electrical worker on a ladder. The employer was very well aware of, was placed in some water in an area that but no, got to get the job done. So the worker injured. Worker sues building owner, but it's a big case.
Okay.
The case goes to trial. I don't know what happened on the comp, and nothing was happening because you were talking about the comp board. The case goes to trial, and there's found to be 25% fault on the employer, not from a workers' comp standpoint, but from this indemnity agreement. Because under the agreement, 1% fault on the employer meant that the indemnity provision would not apply.
Okay.
So we were just looking for 1%, and we got 25%. So that wiped out any indemnity agreement between the general contractor, the owner, and the contractor and the subcontractor. But I don't know how that worked on the workers' comp side. So we think of, is the comp system and that appeals board bound by what happened in the civil court in that trial?
They would be, correct. Yeah, they would be bound. Especially if there's a contract between the general and the special, then they would be bound by that contract. And then under collateral estoppel, it's already been determined in that venue. Then the appeals board would be bound by that as well.
I see. Yeah, interesting.
So, the third party issues get very complex. And you usually try to wrap them all up at once if you can, just because if, from our perspective, if the worker gets a large civil recovery and there's no employer fault, that can effectively end their workers' comp case. And the problem with that is that, they may be getting medical care that they need. They may be on temporary disability, and the insurance company say, well, we have a $200,000 credit now, so the worker has to spend that before we have to pay benefits again. So it's always good to work with your for the PI attorney and the workers' comp attorney to work together to avoid it, in order to maximize what the worker gets overall. Because sometimes it's more beneficial to prosecute the workers' comp case first, maximize that. You have a lower contingency fee recovery for the workers' comp attorney, then you finalize the lien, and then you can more effectively prosecute the civil case.
So in my experience with third-party cases, that is generally what happens. In some cases, one of the parties goes to, generally the insurance company for the defendant in a big civil case goes to the workers' comp people and say, we'll buy the lien. We want to, and they get it at a discount.
Sure.
Buy that lien. Then they own that. And then at trial, they actually get a credit for the amount that they paid.
Yeah, in the higher value cases, that's fairly commonplace as well.
Yeah. Let me ask you, in higher value cases, because we have these things, why would a lawyer, so sometimes we have in a third-party case just notice of a comp lien. It's just the notice. Everybody's on notice. No money gets to be paid out until that lien is compromised or negotiated. But in some cases, the comp people actually intervene. So we go to trial, and they're sitting right there at the table as a workers' comp lawyer representing that that compensation insurance company and what they've paid. Why would that? Why would sometimes you just lien it and sometimes you intervene?
So that's a good question. In terms of from the workers' comp insurance company's perspective, if they actively participate in proving up the fault of the third party, then they can recover. They have stronger recovery rights than if they just passively let the personal injury attorney do all the work. If they don't really do anything to create the fund of money for the injured worker, for the plaintiff, then they have to get in line behind the plaintiff's attorney and automatically reduce their lien by about 40%, because we have to make sure that if the PI attorney did all the work, then he or she has to get paid before they do. So there's instances where they may want to take a more active role in prosecuting their case, or if they don't think that the PI attorney is doing an effective job, then they may pursue that more heavily than if they just simply, like you said, file a lien and then passively wait for the recovery. Mm-hmm. So it depends on the value of the case, and it depends on how aggressive they are in trying to recover.
I see. One of the issues I say is jury perception. So in my experience, jurors kind of want to help somebody who's been injured through no fault of their own, even in the third party. They're kind of, we hear about some big verdicts. But the perception that, okay, there's this lawyer here who works for the comp system, and the jury then understands that, I mean, it happens right in an opening statement, that this worker has been paid and has been paid a certain amount of money. So it seems to me that when somebody intervenes, there is the perception sometimes and the potential that the jury doesn't make
as generous
an award, because they're saying, well, look, this person's already been taken care of.
Yeah, and they're maybe not as eager to make sure the insurance company is reimbursed.
Yeah, exactly.
Yeah, that's definitely a dynamic that can be very real in the Superior Court.
Yeah.
That is one good thing about the workers' comp board, is we don't have to worry about picking a jury or anything like that. You get a flavor of the judges that you're in front of, and it's a broad generalization, but generally they are there because they want to extend benefits, not deny benefits. Mm-hmm. It's at its core, it's a benefit delivery system, and heavy litigation is discouraged. Like, we don't do interrogatories, we don't do production of documents necessarily. Mm-hmm. We don't do. There's no motions for summary judgment. So a lot of that pleading that you see in Superior Court is it's much more streamlined than workers' comp. So it's a nice area of law because you get to engage in civil litigation without all the paperwork.
Yeah. That's great.
And right away, as soon as you get started, you're taking depositions of doctors, of injured workers. You get thrown in pretty quickly, but without all the paperwork that you see in civil litigation. Mm-hmm.
Let me ask you a question. I think it's because I think we do an awful lot of work where people are injured, even have issues of, and then issues come up sometimes about medical malpractice. Mm-hmm. So in the workers' comp field, let's assume somebody is injured, and then there is there's a claim that one of the doctors treating that injured worker, who's within the workers' comp system, mm-hmm. Has committed malpractice. And let's say it's not just an allegation. Absolutely. Left the scalpel in, or the sponge, or, diabetic and cut off the wrong leg. And
right.
How does that work within the comp system?
That's an excellent question, because you see that sometimes where our clients are treating for work comp injuries, and then the treating doctor engages in some kind of accident and makes their disability worse. So that's compensated in the comp system as a starter. So if you have a higher level of permanent disability because of that, it's not reduced because of the doctor's fault. The workers' comp insurance company has to pay that out. So instead of a 50% comp disability rating, I now have an 80%. That's the workers' comp insurance company's responsibility. They have to pay all the permanent disability. Now, in a civil third-party context, the workers' comp insurance company goes, all right, I'm going to file a subrogation claim against the third-party tortfeasor to get some of my money back that I had to pay out. But an exception to that, though, is medical malpractice. They can't subrogate against the recovery that the worker gets in a medical malpractice claim. So that's an exception to that rule. Statutorily, they can't recover for the any kind of medical malpractice recovery the injured worker receives.
So let's say, for example, an injured party has an injured knee, goes to a surgeon. The surgeon operates on them, and let's say confirm that it's malpractice, and the patient dies on the operating table. Mm-hmm. The benefits that go to that person's dependents, let's say, are not reduced in any fashion because of the malpractice of the doctors. So is that right?
That's correct. In that instance, if the death occurs within 240 weeks of the date of the injury, then the workers' comp insurance company has to pay the worker's dependents death benefits. And there's no the death benefits are interesting because it's all or nothing. If just a tiny bit of the death is caused by work issues, then it's considered a death claim. Even if it's just 1% work related, they have to pay the entire death benefit. It doesn't get reduced at all because some of it was non-work related or because the doctor messed up the surgery. They get the whole thing. The only issue is what was the extent of the dependency, and that you get into a lot of fights on that. I mean, there are certain people who are statutory presumed total dependents, and then that's easy to calculate under the labor code how much they get. What gets tricky is trying to figure out the extent of partial dependency, because the statute says you get 8 times the annual amount devoted to the partial dependent up to a cap. Mm-hmm. But that can be tricky to figure out because, people don't live their life that way. They don't say, all right, keep this receipt. This is my, payment of X, Y, and Z. So that causes a lot of litigation trying to figure out what's the extent of the partial dependency. I see. But to answer your question, yeah, you don't reduce the death benefit based on the doctor's malpractice or based on non-work related contribution to the death. Yeah. So in the case in which we were talking about, there was actually, they collected $1 million off the policy of the doctor. The family did. Mm-hmm. So it was a mother and a child, and pretty simple. And the doctor paid, I think, $1 million, something like that, for the malpractice. So that case was settled. But then under the comp system, the comp people would not have any right to lien against that $1 million recovery by those dependents. Correct. They can't get a recovery against the doctor. That's gotcha. Correct. And they can't say, well, you got $1 million from him, so we don't owe you death benefits. It doesn't alleviate their liability to the dependents. Mm-hmm. And that's one thing maybe also worth pointing out is that workers' compensation liability is primary. In other words, the insurance company for workers' comp can't say, well, he's on Social Security disability, so we get to reduce what we owe him in temporary disability. Under the labor code, they can't do that. Now, Social Security can reduce what they're paying based on what he's getting in workers' comp, but it doesn't work the other way. The workers' comp insurance liability is primary, so they have to pay. As long as the thresholds of compensation are met, the insurance company has to pay benefits. Even the exception being if there's a third-party suit that we were talking about. I got it. Interesting. Yeah. So I like these stories. So do you have any more you can you can tell our audience about or tell me about that relate to your work? It's I think one thing is to assume nothing. That's as a lawyer, just in general, you don't want to ever make assumptions. We were talking about the uninsured employers fund, and I had this case where my client was working at a company, and they ostensibly didn't have insurance coverage on the date of the injury, because it's a relatively easy check to find out whether they have insurance or not. And so we petitioned to join the uninsured employer benefit trust fund, saying, well, now you guys have to pay benefits. Well, and so it ended up going to arbitration. Some certain insurance coverage issues go to arbitration at the comp board. They're not heard at the comp board. They're assigned to an arbitrator. And it came out that they previously had insurance with the insurance company, and they stopped paying their premiums, but the insurance company didn't give proper notice that they were terminating coverage. So the arbitrator ordered the employer to pay the old premiums, but then said that the old insurance company was on the hook for comp benefits, and they excused the uninsured employer's benefit trust fund. Because I remember telling my client, well, we're going to have to deal with the UEF, and it can be difficult. It's a lot of paperwork, a lot of delay. And they ended up finding that the employer, even though they hadn't paid comp premiums in a few months, and their coverage had been terminated, the arbitrator still found the old insurance company liable for workers' comp. So it's like you can't ever assume anything's going to go 100%. Our clients are always asking, well, what's going to happen on this? And I always tell them, well, I don't know. It depends. Mm-hmm. It's as a lawyer, just in general, you never know what's going to happen. So it's a little less unpredictable than a jury trial, because juries I understand are very unpredictable. But judges, you get a certain flavor of how they're going to rule on certain things, but you never know. It's like you have to be prepared for anything, I think.
Yeah, we always say that. Well, that's why in your attorney-client agreement, you want to have that disclaimer about guarantee that many don't have. You can't guarantee a result, and make the client well aware of that.
And but one thing I do point out to my clients is that I try to assure them there's really no financial risk. So I had one case where we were alleging that my client developed illness due to toxic exposure at work. And, I had to take deposition of witnesses, and I had to hire an industrial hygienist. And, it's rare that you have to hire a lot of experts in workers' compensation, but this was an example where we did. And we ended up, getting all those costs reimbursed to us by the insurance company. And we ended up getting a pretty favorable settlement for the client. And you don't bear that same risk that you do in personal injury, because if you go to trial on something like that and lose, well, the attorney's on the hook for all that, or the client. So I always tell them not to if it's like I said before, it's a good faith claim. If there's a reasonable allegation that you're making, it's worth at least pursuing. Because the risk is pretty minimal. Mm-hmm. So that is one good thing about the system. It gives access to people who may not otherwise be able to afford an attorney.
I see, yeah.
And the threshold in workers' comp is rather low. I had one client who was working at a building at a school, and he'd been there a long-term employee, and he had developed cancer, and he was seen by the independent evaluator who looked at industrial hygienist studies and the MSDS sheets to see what were the kind of chemicals he would have been exposed to. And you don't have to prove it to a scientific certainty, but the doctor said it was more likely than not that his cancer was at least partially caused by this exposure. And so once you've gotten that, then they're on the hook for the medical treatment for that condition for life, even if it's 99% due to non-work related issues. As long as it's just a little bit work related, the insurance company is on the hook for that person's medical coverage for life. Mm-hmm. And for his cancer treatment, he was in remission, but that was a big benefit for him, is that he had that medical protection going forward. Which is important. That's one of the hallmarks of the workers' comp system, is provide cheap and, in theory, quick, easy access to medical care to help people get back into the labor market. So it's an example of how low the threshold is, and then how just a tiny bit of causation by work issues brings you into the comp system. Mm-hmm. Now, that's not always the case for mental health injuries or mental stress injuries. The threshold is higher than for physical injuries. For mental health injuries, you have to the predominant cause, 51% or higher, has to be due to work issues. So that's an exception to the general rule, is that if it's just 1% work related, then it's workers' comp. For mental health, mental stress kind of claims, the predominant cause has to be work related.
So getting back to your policeman who was totally upset at his job and punched the lockers, maybe it was a mental health issue.
That's certainly an acute one,
yes,
that's for sure. But
yes.
It's understandable for police officers. Obviously, it's a stressful job. But
yeah.
That's a whole minefield of litigation there. Mental health, psychiatric claims, because there's a lot of about 30 years ago, they really increased the threshold for people bringing those kind of claims. And one of the things is if the employer is found to have engaged in a lawful, non-discriminatory, good faith personnel action, if that's a substantial cause of your injury, which is 35 to 40%, then the claim is barred by law, even if the predominant cause is legitimate industrial. So let's say you have an employee and you go to them and you say, you got to correct this or I'm going to have to terminate you. And they have a psychiatric stress reaction to that good faith criticism on your part. Well, then that claim is barred by operation of law, even though it was solely caused by work events, because it was you as an employer, your good faith personnel action was a substantial cause of it. I mean, the problem with that is you're introducing fault into a no-fault system because the worker caused his or her own injury, but the legislature has what's called plenary power over workers' comp. So the courts really defer to their judgment when they categorically take someone out of workers' comp, or on the flip side, if they categorically extend benefits generously like they do for police officers and firefighters, the Court of Appeal has been very deferential to the legislature's ability to do that. Mm-hmm. So they giveth and they taketh away.
So Justin, just to wrap things up, I know we haven't covered everything. We could be here for months and months, and there's so many interesting things in this comp system. But to kind of wrap it up, what perhaps are 3 or 4 things that you'd like our audience to understand and know about this workers' comp system, how it works? So
just in summary, it's a no-fault system, and it's not a lawsuit. If you have a workers' comp injury claim, you aren't suing your employer. The employer's not getting into trouble. So a lot of times my clients are hesitant about filing because they feel like the employer's going to get in trouble or something. But it's a no-fault system. It's very streamlined, and there's never any risk to at least talking to an attorney if you have questions, because he or she won't charge you a fee for at least consulting about an issue. So, and lastly, it's illegal for your employer to terminate you or take any kind of detrimental action against you for filing a workers' comp claim. So that's important to remember as well.
All right. Well, thank you very much for that. Thanks, Justin.
Thank you for having me.
Very happy to have you.
Yeah, thank you for having me. This was fun.
And that concludes this episode of No Holds Barred. Stay tuned for our next episode.